Well, now to the good bit. What does it mean for the sector? Well, at the time the Ag Commissioner process was announced, it was hailed as a big win for the sector. 10 months later, Mick Keogh in the role and the Ag Unit work program underway, it's timely to consider what could be expected from the process. Will it be all things to all people, spiking farm gate prices and propelling us to become the food bowl of Asia? Or alternatively, just a political diversion used to fuel press releases without a real benefit? Well, I expect it'll be neither of those extremes, and that the full potential of the process can be found in its stated objectives, namely improved engagement between the ACCC and the agriculture sector. This may not sound like a revolution, but it's directly responsive to the relevant complaint, and the benefits of properly functioning markets and international competitiveness are real and nothing to scoff at. Now, achieving improved engagement doesn't mean that the ACCC is or has been doing a bad job. In fact, it's a very effective government agency which is highly regarded internationally. But it's the very nature of a cross-sector regulator that means improvement is possible. As bureaucrats covering all sectors, the ACCC staff are necessarily not agriculture experts, and it's always possible for available evidence or nuances of interpretation to be missed, particularly when resources are tight. The nature of the sector exacerbates this, with very limited geographic overlap between the metropolitan base of the ACCC and the regional supply chains. To effectively engage, one party has to travel, and the time and cost of doing so had made this a major handbrake. And then there's the sector itself, which doesn't always hold up its end in engaging with the ACCC. Whereas farmers are capable of identifying competition issues, gathering evidence from the ACCC is often a greater challenge. Gathering evidence is a skill, and even with ACCC guidance through the process, the average market participant can struggle to identify the significance of one piece of information over another. But more significantly, the workload and narrow margins of farming operations can make it impractical to take a few days off, travel to the capital city, meet with the ACCC, and then burn more time at home digging through records, which I'm sure are always in impeccable order. The same goes for agribusinesses, with even medium to large companies struggling to find the latent resources to set up a project team to work with the ACCC on an investigation. The problem is, this is the only way the ACCC is able to get quality evidence to chase down competition concerns. And evidence really is the key point. The ACCC is not the government of the day. It's not a process where you have fireside chats or try and wind them up to take an interest in an issue and then sit back and wait for a result. The ACCC is an independent economic regulator. Its enforcement operations require court proceedings, or the prospect of them, in order to obtain remedies, and this is only possible with quality evidence. For anyone frustrated by this, I can only comfort you that it's the same process for every other sector of the economy, and it's unlikely to be dispensed with. While agriculture is special, it's not that special. So if you want effective engagement or even improved engagement, you've got to see the process through and be responsive to the ACCC's prompts for evidence. They will know what they need, but you have to find it for them. So how can you get involved? Well, I thought it'd be unfair to ask the sector to step it up without explaining what I'm talking about. So I'd like to give a few examples of how it works in practice. The first is in the context of competition analysis. And I thought I'd use the much discussed JBS Primo beef processing merger as an example. The ACCC decision to approve the merger included the following two key findings: that cattle regularly travel distances of up to 600 kilometres from farm to abattoir, and that there were 7 abattoirs acquiring fat cattle located within 500 kilometres between the main JBS and Primo abattoirs. This combination of the ability to travel and the options available within that distance is a recipe for choice, or as an economist would call it, close competitive constraints. On these facts alone, no competition lawyer is going to question the analysis, and it's uncontroversial that the ACCC would approve the merger on this basis. In my professional opinion, 7's quite a lot. And if your choice is being reduced from 8 to 7, that's probably a first world problem. But at the farm gate, these findings were highly controversial. Said to be great on paper, but not in practice. The suggestion that cattle could be moved in a 600 kilometre radius in response to a change in abattoir prices was criticised as being hugely unrealistic, as additional transport costs would be higher than a moderate price increase by their closest abattoir. The fact that all 7 abattoirs were realistic alternatives was also questioned on the basis of differences in services and available capacity at each abattoir. Now, without access to the evidence, It's not for me to comment which perspective is right. The point is that this is precisely the type of evidence that beef producers need to gather to substantiate their concerns. The trade-off between the costs of accessing alternatives and the potential price increase by a merged entity is directly relevant to the ACCC's competition analysis, and evidence of this kind could have changed the result of the ACCC's review. I can only assume from the outcome of the process that this evidence was not made available to the ACCC. But as market consolidation continues, this will remain a live issue. I'm sure the ACCC would welcome any relevant information that can be provided, either in merger reviews or as part of the current market study into the cattle and beef supply chain. The second scenario relates to consumer protection, or fair trading. And here the key issue is the complexity of agriculture markets, and in particular, livestock products. The legal test for whether a product claim is misleading is the reasonable expectations of the consumer. So when a company claims that part of its service is free, the question is whether consumers would reasonably expect that it is in fact free. That's clearly a no-brainer. So when it turns out there's a fee in there somewhere, the ACCC is able to satisfy a court that the claim is misleading without having to provide detailed evidence of consumer expectations. But claims are not always clear-cut, and at the moment, livestock markets are about as clear as mud. There is no one reasonable consumer of food products, but multiple groups of consumers with different expectations and aspirations from the food they eat. Without embracing this complexity, there's a real risk that enforcement action could adversely impact on the competitive process rather than support it. Product claims are currently made in the context of increasing consumer interest in farming practices. The cooking show-driven concept of paddock to plate is now mainstream, but consumer awareness of what it takes to get food to their plate is often fairly low. Meanwhile, animal rights activists and progressive political parties are here to help and give us the truth on farming practices. I can respect a commitment to animal welfare, but the game is pretty clear. In pursuit of their goals, they seem to represent their perspective as that of the wider community, both within and beyond regulatory processes. Now, the ACCC is no stranger to politicised issues. Australians have expectations in relation to fuel, groceries, energy and other sensitive industries, and the ACCC has to maintain the rigour of its analysis in circumstances where the outcome may not be well received by the public. The difference in the agriculture sector is that the noise being generated goes directly to the factual assessment of the relevant legal test. Both the ACCC and the sector need to work harder to ensure that decisions are based on a balanced view. Only a deep understanding of what's really going on in agriculture markets will put the ACCC in the best position to interpret the latest product claims. In this context, the Ag Commissioner process is an absolute gift. It provides a footing to engage with the ACCC and help them build a deeper understanding of farming practices and consumer demand. Most importantly, this process can be conducted on a front foot basis, outside of an enforcement context, and before the ACCC has received complaints or otherwise formed views of the appropriateness of particular claims. So that answers our 4 questions. By way of conclusion, I hope this has provided a sense of the purpose of the Ag Commissioner process and set out a good case for the sector to run a ruler over the work program and decide how and where to participate. It's human nature to be reactive to problems, and the Ag Commissioner process will have benefits for the sector as issues flare up. But the smart play has got to be working out priority issues in advance, whether they represent opportunities or threats, and reaching out to the dedicated resources that have been assigned the responsibility of listening. In doing so, market participants will attract the most from the process if they are informed as to the ACCC's processes, realistic as to the outcome of engagement, and sufficiently focused to see the process through. Just like the Belle Epoque was abruptly halted, this opportunity won't last, and it would be a great shame to look back on what should have been done after the fact. Thank you very much.